day. Good day, good day. I am Tiger Sydney Acute McDaniel, and I am going live today to address some recent incidents of defamation that I've experienced. I traditionally, as has become my tradition, I do directly address these matters in real time, publicly, unapologetically, and directly so. And those of you who know and have been following me, you know this fact to be true. That was redundant, right? Nonetheless, let's see here. I'm going to attempt, I think I can share my screen. I've been fooling around with it here to see exactly what I can do. And I am looking out for your comments, so please do feel free. If you have any questions, feel free to post them and I will comment. And let's see here. I believe I can, I'm not sure. Yeah, I think that I'm remembering I can only choose one perspective, either sharing my screen or sharing my, the view of me. And I have to elect that. I have to choose that prior to the stream. And I don't think there's any way to actually, let's see here. There's no way for me to change that. I can put out polls and all that kind of stuff, but that's about it. All right, so that being said, and let me check just one more time, make sure. Got cross pages, publish a poll. Yeah, it's not giving me the option to turn my screen around. I'm going to do my absolute best with my phone. And I don't want to be on here live because there's really not much else that I need to say except that which I've stated in writing. And I mean exactly that which I say in writing. I said what I said. I meant what I said. And unfortunately for Brittany Johnson and Shamica Smith, that will mean a defamation lawsuit because it has been brought to my attention that Brittany Johnson did not delete her post and instead just untagged me and then kept the post and added additionally defamatory statements on that same post. So let's see here, and that's when you realize what type of psyche that you're dealing with, because generally most people have a healthy understanding that someone who has a Juris Doctorate or who is in or has been in the legal field or that has any damn common sense. Look, we just jumped all the way, right? They would at the very least be able to access your page, even if you block them, from a different page, a different account. We know that to be very common amongst social media in general. And so people should have an understanding that it would be especially more common for people in the legal arena. And that is the case for me. And so I have access. I can pull up information, access pages using my private Facebook page. All right. That being said, y'all, I cannot control the world. I have learned that there are certain dynamics that toxic people use to manipulate a situation, especially if they are in the losing seat, right? So as it relates to Shemeka or Rochelle Shamica Colwell, I don't want to go into much more detail except as to say that instead of correcting her son, she chose to act out in passive aggression, irrational, belligerent, uncontrite, which just means that she did not take ownership. She didn't correct her child. She wanted to put the blame on me somehow, which is just amazing. She wanted to say and have me to really believe that I should have somehow told her in advance or should not have allowed him to have a sleepover or join in with the sleepover that I had at my home for my son and his friends. Number one, that doesn't make any sense because Rochelle Shamica Colwell has 2 children. Those 2 children, they commonly, have been friends with my son. And so I would not have excluded a child. That is not how I operate at all. And I would not have excluded a child on the basis of their, how they identify alone. That also would not be consistent with my core values. And just as I stated in writing, you may know someone, you yourself may realize that you identify as someone in the LGBTQ plus community. That is your choice, and that is your choice when to acknowledge it. It is your choice when to express it. It is your choice when to disclose it, right? But at the same time, those who are in the LGBTQ plus community, most are intelligent enough and they have learned from their parents or their mentors or their whoever their custodial, guardians are. They've learned. Hold on, I can hear you. Asa, I can hear you. They've learned social norms. They've learned about sexual harassment. They've learned what is considered appropriate contact with another person, albeit your friend, for the kids, a friend or a peer or an adult. We've all learned these things. These are, yes, taboo subjects, but in this day and age, we talk about these things. These are matters that are openly taught in schools, of course, with the permission of the parents or the consent of the parents, usually by some type of signed waiver or form. But at the end of the day, your sexual preference does not give you unlimited privy to assert yourself upon another person. Not in a minimal fashion. If it is unwelcome, if there is no consent, then that act constitutes sexual harassment. And the issue is that in the case of Rochelle Shamica Colwell, she failed repeatedly to correct her child. I've known them for about 4 years, and I have brought up various incidents that concerned me as it relates to his behavior, her son's behavior. The child actually exhibits poor general behavior and poor behavior as it relates to what is considered healthy contact and appropriate contact with others. So this has been an ongoing situation that has presented itself that didn't necessarily impact my son directly. And during this sleepover, uh, with other kids, and there was another parent chaperone, so I wasn't alone. There was someone else that saw it, another adult that saw it as well. Her son just continued to persist upon this same type of unwelcome contact with all of the kids, or at least he attempted to. And we would quickly, because we were, we were helicopter parenting for obvious reasons, and we continued to have to correct him in real time. Don't try to hug your friends. That's too much contact. One hug, that's normal. That could be seen as a social norm, as normal, right? But even if you know someone and you've loved them, and even if you're in a romantic relationship with someone, there are times where you can say, okay, I've hugged you. I hugged you, and I hugged you again, and I held your hand. And sometimes too much can be too much. So that's also a social norm for those who are in a consensual relationship, that sometimes they don't want to be touched. And that is your right, because at the point that consent is rescinded, that is where the law steps in and says, okay, after the consent is rescinded, you no longer have consent. I think we all have an understanding of that. This has been reiterated to us legally and socially over the last decade, and it is unclear why Rochelle Shemeka Colwell is projecting as though I have somehow harassed her son by bringing to her attention his inappropriate behavior. So that's what's going on in that regard. She is acting out in a passive aggressive and belligerent fashion, and at the end of the day, I'm not going to entertain it. So in retaliation, of course, she posted that I'm not. I believe that she referenced that the gatekeeper order and the article in the Charlotte News and Observer, which of course you all know is libelous. It is completely false. I have not filed 162 cases in 72 counties of North Carolina. The notion is ridiculous. Some of you know that electronic filing of cases has just become a thing after the pandemic. It was not a thing where you could go and file, a lay person could go, because I wasn't a licensed attorney. I'm not a licensed attorney now, but I am, I have my Juris Doctorate, and so therefore I am considered a lawyer, but I am not yet a licensed attorney. And to my knowledge, 3 years ago, none of the courthouses, none of the county, none of the jurisdictions, none of the judicial districts were allowing for submitting an initial complaint and an indigent form and by way of e-filing. So the notion that I somehow went to 72 different counties in a 2-year period and had active 162 cases, it just doesn't make sense, guys. It doesn't make sense. Like what has been projected as this 162 cases in 72 counties, herein lies the corrupt irony. To obtain the fraudulent gatekeeper order, Richard Huffman, who now is deceased, but there still is a lawsuit against his estate for this defamatory and this defamatory conduct and attorney fraud. He padded his affidavit with a document from court records after he evidently they regurgitated the same record. So they sent out a notification of this gatekeeper order to 72 different counties, right? And so it gives the impression that there are more cases than actually exist, because it has been duplicated in all of these different counties. And that's the only other thing that I can imagine that he, that would be his way of trying to justify what he said is accurate. But a misrepresentation also constitutes fraud upon the court when the intention is to misrepresent and produce some type of injury to the party who would be subject to the gatekeeper order. And of course, a gatekeeper order is a punitive action, right? So of course, his intent is shown through his actus reus, his actions, not only what, his mental intent. We see it with his actions. It's implied by his conduct. When you're misrepresenting that I have filed 162 cases in 72 counties, and you're asking a court to give a enter a gatekeeper order against me, saying that I am abusing the judicial system by filing 162 cases in 72 counties, the clear indication from your actus reus, it's implied by your conduct that you're trying to produce an injury to me. You want the court to put restrictions on me because you're saying that I filed these cases. Number one, I've explained this to you before. Number one, it is not against the law for anyone to file 500 cases in 300 counties throughout the United States. The volume of cases that one files is insufficient to warrant a gatekeeper order. That's number one. So even if I had filed 162 cases in 72 counties, and what? Okay. Secondarily, I believe that I have published, I'm not sure if it's still on my website because I published it to show you how ridiculous the notion was. And I published it in, I want to say 2018, 2019, when I was running for mayor of Charlotte. And I showed you, and I gave you a list of every case number, and I gave you a brief description or disposition for the case. And I had, at that point, I believe almost 50 cases that I filed over the course of my adulthood. Keep in mind that there have been cases that I have initiated as a business owner to recover funds from clients that may not have paid, or from a landlord who owed me money on a commercial property, something to that effect, okay? So they're not all been cases as, like just random cases, if you will. And none of them were random. They were all valid, and there was a lawful claim that was stated, and relief could be granted under law. So I pursued it, and it was proper, okay? And the point I'm getting at is that 90% of those cases were found in my favor. They were decided in my favor. So therein again, if the volume is the only thing that Richard Huffman was claiming was the issue, like the smoking gun, and somehow that necessitated, a gatekeeper order, it doesn't make any sense, because I have won the majority of my cases, which lets you know then that I'm not abusing the court system if a court decided in my favor. You see what I mean? So that you can, lawyers and attorneys and legal professionals and anyone with any type of real, just healthy common sense will look at it and say, okay, well, this doesn't make any sense. You can't just put a gatekeeper order on someone. You can't restrict them. Number one, well, we're at number 3 now. Number 3, constitutionally, no one can be denied access to the courts, right? And the way that they are enforcing the gatekeeper order is in a way to try to win cases against me. And that's what this really is about. It's, okay, Tigress is really good at litigating. How do we cripple her litigation so that we can win against her? And the gatekeeper order is very effective in doing so, because the gatekeeper order requires that I go through a judge who will review and approve my pleadings. Well, what they have started to do, the pattern and practice, is to take their long ass time to review my pleadings, right? anyone who is familiar with the legal system knows that every pleading that is filed to the court, generally, there is a time standard for that. And generally, if you're responding back and forth in litigation, after your initial complaint, the opposing side has like 30 days to respond, right? But after that, and you have these responsive pleadings is what it's called, those pleadings are generally due within a 14, 10-day, and there are some that are even done, even due even sooner. So when I submit my responsive pleading to any pleadings that the opposing side would submit, and you have a judge who knows this, because they cannot not know it, in the capacity of their oath of office and their Juris Doctorate, they are fiduciaries just like me. So they cannot not know it. They are required to know it. It's the nature of their position, right? It's anchored into their position. So they know that I have 14 days to respond. And not only just respond by mailing my responsive pleading, but I must file it upon the court. It must be timely filed, right? Timely pled is also the term. Otherwise, they can dismiss your case for failure to prosecute. And you'll notice that several of my cases, especially here recently, have been dismissed for failure to prosecute on this very basis, because what they do is they have been waiting 30 days. They have been waiting, in one case, there's been 2 years that has elapsed before my complaint was actually reviewed and actually approved for filing. They would wait, they've waited 6 months, they've waited 5 months. None of that none of it is justifiable. It is a clear indication, clear demonstration that they are doing this in bad faith. They have the gatekeeper order in place to cripple my litigation so that they can win cases against me. And that's what this is really about. So the fact that someone would try to use it, like Rochelle, Shamica, look, I can't even say it, Colwell, just shows the ignorance, the audacity, the audacious ignorance of it all, that she would think that presenting this libelous article somehow is proper and somehow is a winning blow in retaliation for her not addressing her child and not being honest with herself about what her son is experiencing, getting her son the guidance. Because I'm not just talking about like counseling psychologically. I'm not saying that because he may be a part of the LGBT plus community, that he is psychologically off. I'm not saying that. I'm saying that he would need counseling and mentoring in a healthy way so that he can understand the dynamics with regards to how he identifies and how he presents himself. So that's what that is, right? That's that part. Now, so you saw, I addressed it. They should have gone away. I haven't seen any more posts. I will monitor it. Please feel free to bring it to my attention, but it just it's her issue. It has nothing to do with me. It's her issue with her son, and I just hope that the young boy gets the guidance that he needs so that he can actually learn how to best manage his general behavior and also manage his behavior as it relates to unwelcome touching and sexual harassment, and whether or not he identifies as LGBTQ+. Okay? All right, so that's that part. Okay, now on this side, we've got Shemeka Smith, KJ Johnson, and a Brittany Johnson. So you notice if you haven't had a chance to read it, go and take a look. I'm just going to give you a very quick synopsis here. So basically, if you're aware, I started the Ethical Gatekeeper in anticipation of obtaining and, pursuing and obtaining my license to practice law. Under or through the Ethical Gatekeeper, it's a company, of course. I offer legal coaching, research, vocational legal education, and legal document preparation. Shemeka Smith was a +1 at my celebration for my graduation about 3 or 4 weeks ago at this point, and was introduced to me as someone having need of legal services. And I explained to her that I was not a licensed attorney. I could not be her legal representation. And you all know me to be pretty transparent, as I was consistently with her. And you can read the membership agreement on my website at theethicalgatekeeper.com. Of course, they get a copy of it upon joining. I asked them to read it. I asked them if they had any questions about it. And of course, at that point, when consideration is proper, which is them paying the $50 and then agreeing to the terms, then we have a contract, right? Well, my contracts, even for my business consulting, I have standards. I have a performance contract that I execute with my clients, even on the business consulting side, that sets forth certain ethical standards. And so you can imagine the name of my company, the Ethical Gatekeeper, and considering that it's legal now, right? And considering everything that I have experienced as it relates to the wrongful felony conviction and defamation, I am very, very insistent upon making sure that my client understands everything. So there is nothing that they can bring back later and say they're confused about, or try to throw it up in my face and use those things. Well, this is one of those situations where they did it anyway. They claimed that they had read it. I asked them on several different occasions if they had read it, because their actions were not demonstrating that they had read and understood the terms of the agreement. And they would continue to tell me verbally and in writing that they did understand. And we basically found ourselves at an impasse, because we got to the point where we're no longer having an issue with them making minor violations through their demonstration of non-compliance with the membership agreement terms. We got to the point where Shemeka Smith actually had defrauded documents to pad or to misrepresent a domestic violence protective order or a petition for that, and as it related to the temporary custody agreement for their child. And at that point, I knew I could no longer offer her services. I did give her an opportunity to cure the issue, and I confronted her and her partner about it, and I required a letter of affirmation affirming that they fully understood that I would not assist them with manipulating the court system to strip the father of his parental rights. I wanted them to also affirm that they understood that the constitutional rights of a father are, that's a stronghold and very unlikely to be, abandoned. That would take a change in constitutional law. And we know how long it takes to change a state law or a city ordinance. A constitutional law takes a lot more steps, a lot more bureaucracy to get changed. So it would be completely unrealistic for them to continue in this process without fully acknowledging that at the end of this, the father would still have his parental rights intact, unless, of course, the father had done something so egregious or so heinous as to shock the court and merit stripping his parental rights. But then I also asked them to further affirm that if that father were to better himself, let's say after some bad event and he showed the court, he demonstrated that he was an unfit parent, and they stripped his rights, albeit minimally, to the point where they had supervised visitation. I asked them to affirm that they understood that, and that they further understood that if he further bettered, if he engaged self-improvement in classes and could further show the court that he was a better man and a better father, that the court would then consider on his petition to change the supervised visitation to unsupervised visitation. And then from unsupervised to, joint custody. So the point that I was insisting is that I need you, Shemeka Smith, and KJ Johnson to understand that there is no legal tool and there is no law that can even be manipulated to get the end result that you all have consistently either demonstrated by your actions or demonstrated by your words, albeit these casual remarks like, we want to get him out of our hair for good. I want him to give up his parental rights. Those statements are red flags for attorneys and legal professionals, and as was it a red flag for me. And so this is what this stems from. Because they would not complete that affirmation letter. They danced around tried to negotiate and manipulate me in this conversation and all this circular arguments. And I told them, as I told them in the beginning, I stand firm. I'm exactly who I am. And they've seen that. They've seen that pattern with me. And I guess they thought we'll try one more time to get her to do what we want. And ultimately, I decided, even after offering them private mediation, and I mean private mediation between the father and the mother, at that point, Shemeka Smith became very disrespectful with her words toward me, and that is also a major violation of the ethical gatekeeper oath of ethics and membership ethics. And at that point, I advised her that her membership would be terminated immediately and permanently. And the same thing for KJ Johnson, because they were not good candidates for membership with the ethical gatekeeper. They could not and had consistently demonstrated character that was completely inconsistent with the policy of the ethical gatekeeper. And as you can imagine, then the retaliatory defamation popped up again, because why else? You know what I mean? Like, why not just clearly, like, they met me at my party. And some of you, of course, you weren't at the party, so I'll inform you. At the party, you can imagine that I would share about my experiences facing the criminal charges, and then full circle being able to graduate from law school, because it would make sense. It's relevant, it's an impactful story, right? So they knew about this. So it's like, okay, we're going to use this information against you now in retaliation, but it's empty retaliation, because it's not like I committed something against you and now you're retaliating against me. It's completely unprovoked. You're like, okay, because she is standing her ground in her ethics, we're going to be mean to her. Well, that doesn't make any sense. That's completely imbalanced. So basically, that's what I'm dealing with. And I further found myself in a situation where Shamica's psyche was further revealed when I had explained to them that I would return some of their documents, right? The lawyers generally keep a binder, and that is called the work product of an attorney or a legal professional. And that is not necessarily the property of the client, okay? The work product remains in the possession of the attorney for obvious reasons, maybe future needs, current needs, whatever. Even after that attorney if their representation is terminated or they withdraw from the case, either way, they still have privy to those documents for obvious reasons, right? And so the binder that I created is just copies of all the case records from the case, and all those things are public record. A lot of you know this. You can go right up to the case records room and you can copy every single piece of paper in the document. You can even make a copy of the damn file. It's like a manila folder, you know, the hanging folders type of thing. You can make a copy of that too if you want to, okay? So her being belligerent and demanding that I return all of her documents was just ridiculous. It was a ridiculous notion, and her insistence that that she needed her documents in order to file something in her case, another really, really ridiculous notion, because in my experience with her, and I'll say this in a nice way, even though I may not have said it as pleasant as as I'm going to say it now in the comment, she is not apt enough to, well, she is not apt at all, but she is not apt and cannot litigate this case on her own at all. So the fact that she would try to convince someone that she needed these documents, you know, trying to create this urgency, I need these documents because I need to file something into my case, and doing so at 6 o'clock in the afternoon on yesterday after the courts were closed it was strange, especially considering the fact that I said that I could meet with her the next day in the morning. Oh, I can't meet with you. And ironically enough, after it was all said and done, she had to comply with meeting me at the courthouse today as I had directed her. But basically, she actually showed back up at my home. And I had already told them, based on their behavior, that they would no longer be welcome at my home, and I would meet them at a public place, the courthouse, case records room, or the family court room, to give them the documents, right? So when me and my son were coming back from a quick break, because I was working all yesterday, working on another case, and had a time-sensitive pleading to complete, we're coming back, and I actually hear her yell out, "Tigress," and I turn around, and it's her. And at my property, we do have a co-work area, so that's how she's familiar with where I live, because I have met with her here in the co-work space and the rooftop, but she has not ever been in my home, and that was intentionally so. So that's what I'm dealing with, and evidently Brittany Johnson evidently is a friend of hers. The irony is that she was also a +1 at this party, and even more ironic, they both were, "Oh, your story is so amazing. You're such an amazing person. You're just a wonderful person. And then you see how quickly they showed their truest colors in their behavior today. So there you have it. That's what's going on. I know it looks cuckoo crazy, but you know I'm going to shut it down. So all of it's been shut down. And again, there will be a defamation lawsuit that I'll have to file, unfortunately, against Shamica Smith and Brittany Johnson. I may include KJ Johnson, but I don't have any direct proof that she has actually participated in the defamation. But if I do learn that she has, of course, she will be joined as a co-defendant with her girlfriend and her friend, I guess. So, but I don't know any of them personally. I just met them at this point, maybe at best 4 weeks ago. And that just shows you just how quick I can decipher if someone is trying to pull a trick or not. Especially considering that, you know, I don't see them every day, and I'm looking at the paperwork and all these things, and it was pretty quick. It didn't take. I know her. The attorneys were with her for well over a year. It took me 4 weeks to find the bullshit, and that people is a great way to end this live. I'm quick in finding the bullshit. So when I run again for our office, any office, you need to select the box that says that, you know, the box right beside Tiger, Sydney, and Cute McDaniel. Because, yeah. I don't even know what else to say. I thought there was one other thing I wanted to mention. And you can tell I'm completely dressed down. I've been running errands with my son today. And I came home, and no sooner than I'm checking my email and responding to texts, and I noticed that I had that notification around, I guess it was around 5:30ish, something like that. And then I saw it, and of course I responded to it all. And then I decided, you know what, maybe I need to go ahead and go live, because I had suggested I would go live. I would like to guide a conversation on children and sexual harassment and the LGBTQ plus aspect. But I want to hear from you. Let me know how you feel about that, if that's something that you're interested in. And then we can definitely have that conversation. Some of you know that I have mentored young kids for, good gracious, at this point, over 26 years, since I was 20 years old. Actually, yeah, since about 20 years old, beginning in college when I was Miss Alpha Tau Alpha, which is a agricultural honor society, which also puts you on the Queen's Court. So I was part of the Aggie Queens, which was all the queens on the university that came together, and we mentored preteens at local middle schools. And I've been doing that, you know, all my life in some capacity. Children, adolescents, teenagers, and young adults up to about 25. So the point I'm making is that I can definitely lend my expertise and my insight to guide that discussion, but we need to definitely make sure that our children are learning proper social norms and healthy ways to express themselves without encroaching, you know, the word, upon other people. I always get that particular word incorrect. Let's see. Yeah, I said encroach. Yeah. But yeah, that's what's going on. I am not sure when I will resume my Evolve Weekly, but I thought it was also necessary to just kind of, you know, squeeze this in as well. I do plan on resuming Evolve Weekly very soon, and the strategic implementation plan, right, for a more perfect union, I do plan on resuming that as well. We've got half of the states still left. We've covered a lot of states, covered a lot of ground, but I will get back on that very soon, and I will definitely post updates. If you're not following me on all social media, please do. It's See Tigress Run everywhere, even on TikTok. And otherwise, if you have any questions about anything that I have shared in this particular video, it's a very casual one, laid back, informal, but I just wanted to make sure that you actually saw me, you heard my voice. You know how they say you hear it from the horse's mouth, right? that you heard me, that I explained to you what was going on, and there you have it. And she's got it handled because I'm from there. Y'all have a good night.